So let us now move to sources of international law. So when we talk about sources of international law, the document which we look at to find a mention of sources of international law is called as Statute of International Court of Justice. What is this document? As most of you would know, that there is an International Court of Justice, which is also known as ICJ in its abbreviated form. ICJ is one of the chief organs of the United Nations. United Nations is a public international organization, as most of you would know, and United Nations has 6 chief organs. We'll discuss about United Nations in detail in our coming lectures. But as of now, it's important to note that ICJ, which is International Court of Justice, is one of the chief organs of the United Nations. And United Nations is one of the international organizations. But international law is not only about United Nations. Besides United Nations, there are other international organizations also. So, International Court of Justice, which is one of the chief organs of United Nations, its constituting document, the document that governs it, is known as Statute of International Court of Justice. For example, if I have to draw an analogy with the Indian legal system, the Constitution of India is the backbone legal document that from which other laws emanate from, right? So similarly, and Constitution of India is a document where we can trace the powers, role, duty, responsibilities of the government and its agencies primarily. So similarly, the Constitution of International Court of Justice is known as Statute of International Court of Justice. And this document you find it as an annexure to the Charter of the United Nations. But it's not a part of the Charter of United Nations in that sense, because it's altogether a separate document. Now, Statute of International Court of Justice talks about the role of the court, the ICJ, its power, duties, responsibilities, the tenure of judges, how the judges are selected, etc. Now, in this, one of its provision, which is important for our discussion today, is Article 38, Clause 1. Why? Because Article 38, Clause 1 talks about sources of international law as applicable in International Court of Justice. Because it uses the word as applicable in International Court of Justice, that would mean that Statute of ICJ talks about these 4 sources. There are 4 sources enlisted. So it talks about 4 sources which are sources for the purposes of deciding any case that comes to International Court of Justice. That means that there may be some other sources of international law also. But statute mentions these 4 sources. So let us see what Article 38, Clause 1 reads. It reads as, the court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply. It reads that this court should apply any of these sources, right, to decide any international dispute that comes before it. The first source is international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. That means that any international convention, now what is a convention? We'll talk about this in detail. So it talks about first source as being the international convention. Second source is an international custom as evidence of a general principle accepted as law. Third is the general principles of law recognized by civilized nations. And fourth is, subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of various nations. So, 4 sources, if we talk about the sources in short, then there are four sources of international law as per the statute of ICJ Article 38 Clause 1. One, international convention. Second, international custom. Then general principles of law, and then judicial decisions plus the teachings of most highly qualified publicists in the field of international. So let us now try to understand what are international customs, what are international conventions, etc. So let's begin with international customs. So as I said, to summarize, these are the four broad sources of international law. But these sources, as I said, is this list of four sources is non-exhaustive. There may be other sources also. But for the purposes of statute of ICJ, there are these four, right? Treaties, customs, general principles of law, and judicial decisions and views of highly qualified publicists. The treaties would be A, customs would be B, C is general principles of law recognized by civilized nations of the world, and D would be judicial decisions plus views of most highly qualified publicists. Right. So let us start with point A, international convention. What is an international convention? So if we go here, you would see that I wrote treaties instead of convention, right? So conventions or treaties are used often interchangeably, and convention is a kind of international contract or an international treaty, which would mean that there are contracting parties, and these contracting parties are states. So when states of the world community come together and draft a piece of document for themselves, which they say, they promise that they will abide by that document, and the document has certain legal obligations for all the states who are signing it, who are in the negotiation process, then the outcome of that negotiation, the draft when it is finalized, is known as an international convention or a treaty or an international contract. So in simplest terms, if you understand what a contract is in domestic sense, then a convention is an international contract, right? The contracting parties are not individuals but states of the world. So therefore, you see words like contracting party, state party used in case of convention. Convention can be loosely referred to as a treaty, which is an international contract. This I say in layman's term, but if we talk about treaty, there are several kinds of treaty, and there are differentiations between different kinds of treaties on various bases. So there is differentiation on the basis of open treaty, closed treaty, time-bound treaty, or otherwise geographical treaties. There are several categories of treaties, but for the purposes of our discussion today, we'll focus on one distinction between treaties, that is one broad distinction, which is law-making treaty and treaty contract. So not all treaties create law. Some treaties do, some treaties do not, because there is a category that is law-making treaty or law-creating treaties that create some kind of law because they embody some legal principle or rules, and states negotiate that, okay, these are the legal principles that we abide by. While on the other hand, there are treaty contracts where treaty necessarily does not create a law, but it is more of a contract between states. So let us understand this more by way of examples. So treaty making contract is essentially a process where the states, the head of the states, they would on their, either them or on their behalf, some other person representing the head of the state is sent to a negotiation process where a treaty is negotiated. A treaty may be negotiated in the duration of, few days, few months, or it may take years in drafting a treaty. And various provisions of the treaty are negotiated upon and debated upon whether to have this provision or not to have this provision, whether to have this phrase or not to have this phrase. And ultimately, when the provisions of the treaty are negotiated upon by the state representatives, then all those provisions in a draft form are signed by those representatives. And those representatives are basically representing the states. So it is as good as states signing that treaty, a treaty which has legally binding rules, a treaty which has legal principles. So that makes it a law creating or law making treaty. And once that treaty is negotiated, comes to a final stage, and then finally it is signed, then it is open for the state parties to ratify it. Now, please understand that signing and ratification, these two are different stages. As one stage is either the head of the state or any other person acting on his behalf representing the state is sent to a negotiation process, this as one step, negotiation process, entire drafting process as second step, and the final outcome of negotiation, which is a treaty, as the third step. And now this treaty is signed by the representatives of the state or the head of the state. This would be a fourth step. Now, once all this is done, once a treaty has come to finality, come to actuality, and it has been signed by the state party, then suppose this treaty has been signed by state 1, 2, and 3. Now this treaty is to be ratified. Now, signing the treaty is signing the treaty, but ratifying is this ratification is a process where a state establishes on international plane, international platform, that yes, we promise that we will abide by the provisions of this treaty. That would mean that signing itself is not enough for a state to abide by the treaty. For a state to actually abide by the treaty provisions, the provisions that are there in the treaty, a state has to ratify a treaty. So signing is not enough, but ratification is also needed. So a state must abide by the treaty provisions. Treaty provisions are the rules embodied in the treaty. So a state must abide by the international law rules embodied in a treaty once that treaty is signed and ratified, not just signing. So mere signing of a treaty will not make a state compulsorily abiding by the treaty. So signing plus ratification. Ratification is a formal act where the state promises to the world community, to the international legal society, that we will now follow the provisions of this treaty. So signing plus ratifying, these two are important steps. These two steps must be there for international law in a treaty to bind a state, so to have obligations on the state. So state must follow what is written in a treaty once that treaty is ratified by that state. Mere signing will not ensure that, right? This, we are talking about law-making treaty. So in law-making treaty, there are legal rules which are negotiated upon. It comes to a final stage, it is signed, ratified, and once it is signed and ratified both, then it applies on the state which has signed and ratified it, right? So as we were talking about state 1, 2, and 3. So if state 1 signs it but does not ratify it, the treaty will not be applicable on state 1. State 1 may follow it or may not follow it. If state 2 has signed the treaty and ratified the treaty, then state 2 now, because state 2 has promised on international platform by ratification that we'll follow this treaty provisions, that is why state 2 now must follow. State 2 is now obliged to follow the treaty provisions, right? So this is about law-making treaty, where a treaty has some legal principles or rules which, once a state signs and ratifies, are binding on that state. Now, if we talk about treaty contracts, treaty contracts are also treaties where once they are signed and um, ratified, the states which have signed and ratified it must follow it. But then these treaty contracts do not have legal principles. So what do they have? So treaty contract, an example of treaty contract may be a contract between states for the production and sale of, for example, fabrics. It may be for production and sale of some seasonal fruit or some other food product. So treaty contract, if so suppose if you assume that there is a contract between India and few other um, states of the world on production and export of mangoes during summer season. So that would, if that is governed by a treaty, that treaty necessarily, you would understand by this example that that treaty does not create legal principles, but that treaty talks about some obligations on how the mangoes, or in what quantity, or during which season, or what would be the modalities of export of the mangoes, right? So treaty contracts, such kind of treaty contracts, for example, trade related, investment related, may be examples of treaty contracts. I do not mean here that trade related treaties do not create law. Trade related treaties definitely can create law. But then the point that I'm trying to make here is that treaty contracts are where which have contractual obligations for the state parties involved, and they do not necessarily embody legal principles or rules that can be applicable on other states also, right? So lawmaking treaty would be, for example, CEDAW, Convention on Elimination of Discrimination Against Women, which is known as CEDAW in short. Lawmaking treaty would be Convention Against Torture, CAT, CAT in short. Another example could be Convention Against Elimination of Racial Discrimination, CERD, CERD. Now, these all are examples of treaties that have legal principles embodied within them. And once the state parties sign and ratify these treaties, then the states are obliged to follow these treaties, right? So therefore, treaty becomes a very important source of settling international law disputes between states by the ICJ. How? Because, for example, there is a treaty for extradition, or there's a treaty on asylum, or there's a treaty for uh, sharing of river water, interstate river water, that is a river that crosses the international boundary. So there's a treaty on sharing of interstate river water, and one state follows the provisions of that treaty, and other state which has signed and ratified but does not follow the provisions of that treaty. In that case, state 1 which follows and wants state B to follow may take state B to ICJ and say that, okay, this is the treaty that both of us had signed and ratified, and now the other state is not following the provisions of that treaty which it is bound to follow. So it is violating the treaty provisions by not following it, right? So for the purposes of this international law sources, and in international law sources specifically contained in Article 38 Clause 1 of Statute of ICJ, lawmaking treaties are the treaties that are the sources of international law. Now let us move to custom. So when we talked about custom, when I read Article 38 Clause 1, Subclause B, which talks about custom, Subclause A talks about international convention, Subclause B talks about custom. So when I read out the provision of custom, it said that international customs which are observed by the states, which have the force of law, right? So let us go back to this and see. Yes. So international custom as evidence of general practice accepted as law, right? So there has to be international custom. Which international law custom? Not every custom, but those international customs which have evidence of general practice accepted as law. So general practice is one phrase to focus upon, and another phrase is accepted as law, right? So let us deconstruct this general practice and accept it as law. So here, a custom must have two elements as mentioned in Article 38, Clause 1, Subclause B. First element is state practice. State practice is where there must be evidence. If a state is argued to be under an obligation to follow international custom, then there must be an evidence to prove that that custom was there, and that custom is there because of two elements. Now the state, it must be proved that the state previously in the past had displayed such practice in relation to that custom. So for example, if there is a question of, for example, asylum, that state A is if state A is putting an allegation on state B, that state B is under an obligation to give asylum to person 1. State A must prove that state B had a custom of giving asylum previously, and therefore it is now under an obligation to give asylum to person 1 also. Now to prove that, state 1 must show that state B had a practice. State 1 must show an evidence that state B previously used to practice this asylum giving to asylum seekers, right? As I said that there are two elements. State practice is not enough. State practice is one element of custom. Other element is opinio juris. Opinio juris, where J is silent. Opinio juris means accepted as law. So I said that the two phrases to which must be focused upon. One is general practice, which is state practice, and another is accepted as law, which is opinio juris. So opinio juris literally means accepted as law, or something which has the force of law. That means that to prove that B is under an obligation to give asylum, just to show an evidence that B used to do this, used to practice giving asylum is not enough, but it must be shown that opinio juris was there. Opinio juris was there, that would mean that B was practicing giving asylum. Why? Because B thought that B giving asylum has a force of law, or it is accepted as law. It is not law because it is a custom, and it has to be recognized by International Court of Justice as a custom to be called international law custom. So it's not law, but it has been accepted by state B as law. Or state B thinks that give asylum is an obligation similar to law for state B. So state B, with that sense in mind, state B used to give asylum to asylum seekers. So therefore, state practice is a practical element, and opinio juris is a psychological element, that a state is practicing this thing, but practicing this thing with a sense, not as a morality, not as a courtesy, but practicing this as a sense that it is the state B is obliged to do this because it has the force of law, or it has been accepted as law. Because opinio juris is a psychological element, it is very difficult to prove opinio juris in any court of law, right? So, but for any custom To qualify as international law custom, to be proved as international law custom, it must have both this element. Having one of these does not suffice. So state practice and opinio juris both must be there in an custom, in an international custom, to prove itself to be actually an international custom before ICJ. And who decides which custom is actually an international law custom for the purpose of sources of international law? As I said, this is decided by ICJ. So there may be a custom which a state feels that, oh, this is a custom because this has both the elements present, state practice as well as opinio juris. But once you argue, the state argues before the International Court of Justice, and International Court of Justice accepts that yes, this custom is an international custom, only then it will be an international custom. It won't be an international custom if one or two states believe that, okay, international law custom is there. Even if it is there, it has to be proven to be so before ICJ, right? So, in short, state practice, opinio juris are two elements of an international custom. Both of them must be present there to prove a custom to be international law custom, right? So this is the second source of international law. Now let us move to the third source, which is general principles of law. So general principles of law are certain principles which are accepted as principles of law and are present in most of the developed legal systems of the world. So, for example, there can be certain principles of law from administrative law which are common in most of the legal systems of the world, the national legal systems of the world, and therefore they have a very significant relevance in international law also. So, for example, pacta sunt servanda. This is one of the general principles of law of contract, which is present in most of the national legal systems. Pacta sunt servanda literally means pacta is pact. Pact is a promise. Sunt servanda is servant. So this means that you are pact of the servant. That means that once you have entered into a pact with other person, then you are servant of that pact. That means that you have to follow what you have promised. You have to follow what pact has said. You've promised with other person that we will go for a road trip to a forest on Sunday. Now you're servant of this pact, servant of this promise. Now on Sunday, if you want to go for football and not on road trip, then you will violate this pact, right? So you've become servant of the pact in that sense, because pact is sacrosanct. Once you've entered into a promise or a pact, you have to follow it. So that justifies this literal translation of pacta sunt servanda, that you are servant of the pact you sign, right? And this, in essence, means that the treaty obligations. So pact is a treaty, pact is a promise is a contract, right? Promise to do something. So contract is a promise that, okay, I will do something in lieu of something. In that sense, whatever promises are made by states of the world, that must be followed. So that also means that treaty obligations or contractual obligations. In the example we took, the obligation of going on a road trip to a jungle on Sunday. This is an obligation casted by the pact. These obligations must be followed. The obligations must be carried out in good faith. So pacta sunt servanda means, in contractual law terms, it means that the treaty obligations or contractual obligations must be followed or carried out in good faith, right? Now, pacta sunt servanda, although is an example of general principles of law, because it is present in most of the national legal systems in their contract laws. It is there in Indian Contract Act as well. So because it is there in most of the national legal systems, I classify this as a general principle of law. But at the same time, pacta sunt servanda is an important legal rule which has a customary status also. And it earlier had a customary status, but it has been included as a treaty provision in one very important treaty of international law, which is Vienna Convention on Law of Treaties, VCLT in short. The Vienna Convention on the Law of Treaties embodies this international custom, pacta sunt servanda, as one of its treaty provisions. So, pacta sunt servanda was an international custom. It became a custom because it was observed by most of the national legal systems of the world. But after VCLT coming into force, it has also become a treaty provision, right? So, this is an example of all three sources of law in that sense, right? Now, let us take another example of general principles of law. Another example, as I said, that most of the principles of administrative law would also be examples of general principles of law. So, principles of natural justice, for example, audi alterum partem, hear both the parties, would be an example of this. Then res judicata, which is an important principle in civil procedure law. This also is present in most of the national legal systems. So this would also be an example of general principle of law. The principles of law relating to self-defense, for example, in penal codes of most of the national legal systems, they talk about self-defense being a major exception or a general exception to the criminal laws or penal laws. This would also be an example of general principles of law, right? Similarly, equity, good conscience are also examples of. Now, the fourth category, which I just discussed, that fourth category is judicial decisions of international courts, sometimes also national courts, plus the views of most highly qualified publicists in international law is also one of the sources of international, right? So now that we have discussed the nature of international law, the characteristics of international law, the distinction emanating from the difference between international law and national laws, the difference in subjects of international and national laws, and then discussing about the distinction between private international law and public international law, and then eventually coming to the sources of public international law. I believe that most of us are in a situation to now look at certain questions based on our discussions today, right? So most of the questions that you would find in your CLAT UG exam would be based on a paragraph or an excerpt from any source. For example, if you see the previous year question papers, you have questions from online platforms, from newspapers. For example, there are questions from The Wire, The Quint, The Print, Indian Express, etc. And these excerpts talk about something on some legal principle, and based on that excerpt or that passage, you have 5 or 7 questions which you have to answer. So we are not talking about passage as of now. We'll just talk about few questions which are in line with certain questions based on paragraphs of previous year question papers. Let us see some questions. Let's start with question number 1. Which of the following is incorrect? Option A, international law is a compulsory legal system. B, international law is a consent-based legal system. C, international law is a voluntary legal system. And D, international law is distinct from domestic law. So what do you think should be the right answer based on our discussion? Let's revisit the options. Option A, international law is a compulsory legal system. That would mean that all states must follow international treaties or international customs, which we have seen that it is not true. It's not compulsory. International law is a consent-based legal system. Yes, it is consensual legal system. International law is a voluntary legal system. Yes, consent-based would be voluntary. A state may volunteer to sign or ratify a treaty. State may not volunteer to sign or ratify a treaty. A state may voluntarily follow an international custom. A state may not voluntarily follow an international custom, right? So international law is a voluntary legal system. D, international law is distinct from domestic law. Yes, it is very distinct from domestic law. That is why international law's nature is entirely different from domestic law nature. That makes us tick option A as the answer. So international law is a compulsory legal system is an incorrect statement. Now let us move to question number 2. Question number 2 says, which of the following is correct? A, international law is a vertical system of law. International law is a horizontal system of law. International law is centralized. International law is analogous to domestic law. So, option A, international law is a vertical system of law. No, because we discussed that domestic law is a vertical system of law. There is centrality of authority, but international law lacks that centrality, lacks that vertical system of vertical flow of power, authority, or laws, right? All states are equal. All states are on one platform. So, A would be incorrect. Option B, international law is a horizontal system of law. Yes, we discussed that international law is horizontal because all states are on equal pedestal. C, international law is centralized. No, we discussed that international law is highly decentralized. D, international law is analogous to domestic system. No, we discussed that it is not analogous to domestic system. It is rather very different from domestic system. So, international law is a horizontal system is the correct option. B would be the correct option here. Let us proceed to question number 3. Question number 3 reads as, which of the following is correct? A, municipal law is a vertical system of law, while international law is horizontal. B, international law is a centralized system of law, while municipal law is decentralized. C, international law and municipal law both are centralized systems of law. D, international law has coercion, while domestic law lacks coercion. So, if you see option A, it says municipal law is a vertical system of law. True. While international law is horizontal. True. B, international law is centralized system of law. Untrue. So we are not going to the second part when first part is itself untrue. C, international law and municipal law both are centralized. Wrong. D, international law has coercion while domestic law lacks coercion. We took examples of traffic laws and penal laws and saw how domestic law has coercion in comparison to international law, which does not have. So that makes us go for option A as the answer. Municipal law is a vertical system of law, while international law is a horizontal. Now let us go to question number 4. It says, which of the following is not a source of international law? First, A, international convention. B, international customs. C, general principles of law. D, international moral conduct. So, we just discussed these 3 as sources of law, but international moral conduct is not a source of international law, right? So, D would be answer to question number 4. Let us now go to question number 5. It reads, which of the following is a source of international law? A, international customs. B. International ethics. C. General principles of morality followed by civilized nations. D. International conduct of morality. So, international ethics is certainly not a source of international law. International conduct of morality is also not a source of law. International custom is. I've included option C to confuse us because general principles of law followed by civilized nations is a source, but general principles of morality are not. So pay attention to minute details in the alternatives that you get in questions. General principles of morality makes it a wrong alternative, but if it had general principles of law, it would also have been correct up besides A, right? So this morality is inserted instead of law to confuse us, fine? So these three would be wrong, and the option A will be the correct answer because international custom would be a source of international law, right? Let us now proceed to question number 6. Question number 6 reads as, which of the following is correct? A. Public international law is distinct from private international law. Yes, we have read this. Private international law is also known as conflict of laws. We have read this also because private international law is more like conflict of which legal system to prevail when there is a dispute or between individuals belonging to different nationalities. So private international law is also conflict of laws, which law to prevail, which law to be applied, right? The international law is essentially between the states, while private international law is between individuals of different states. Yes, we discussed this as well. D. Public international law deals with individuals of different states, while private international law deals with individuals of same state. D is completely wrong. So, A, B, and C are correct, and D is wrong, right? So this question, I think, is misspelled. It should have been which of the following is incorrect. So D is incorrect, and that is D. That is why D is the answer. All of these statements, all three, A, B, and C, are correct. Let us now move to question number 7. Which of the following documents enlist the sources of international law? A. The Charter of the United Nations. B. The Covenant of the League of Nations. C. The Statute of the International Court of Justice. And D. The Rome Statute. So, we just discussed that the Statute of International Court of Justice is the document that talks about sources of international law, right? So, C would be our correct option. Let us now see question number 8. It says, which of the following elements constitute an international custom? A. State practice. B. Opinio juris. C. Both state practice and opinio juris. D. State practice or opinio juris. So, or and or between two phrases would mean either of these, either state practice or opinio juris. So if state practice is there, even if opinio juris is not there, it would be a custom. We know that this is not so. We know that both state practice and opinio juris are needed because these both elements are important to constitute a custom as an international custom, right? So that would make us choose C as the right answer. Question number 9. It reads, which of the following is true? A. For a treaty to be followed by states, it must be signed by that state. B. For a treaty to be followed by states, it must be ratified by that state. For a treaty to be followed by state, it must be negotiated by that state. For a treaty to be followed by state, it must be signed and ratified by that state, right? So here it says it must be signed. mere signing does not make a state obliged to follow the treaty. We just discussed this. So A is not so correct. Treaty to be followed by state, it must be ratified by the state. This looks to be correct. C, for a treaty to be followed by states, it must be negotiated by that state. No. But if we read option D, it says signed and ratified both. Right? For a treaty to be followed by state, it must be signed and ratified by that state. If we read alternative B, we may in hurry just tick option B as the correct one, but we must pay attention to all the options. All the options, if are given in the question paper, they are meant to be read and read in detail, right? So option D is correct. In such questions, please don't take option B in a hurry, but C, signing, ratifying, both are important for a state to be under an obligation to follow a treaty. So D would be the correct answer. So I believe that our discussion today has been quite varied in terms of nature, characteristics, distinctions, and sources of international law. And these all are the backbone of understanding international law and its other concepts that we'll discuss in our future lectures. But whatever we have discussed so far, I would suggest all of you to have a rehearsal, to rehearse these concepts by looking at previous year question papers or model question papers on international law questions, so that you see whatever we have discussed so far, whether you actually understood it or not, or whether you're being able to attempt the answers correctly, attempt the questions and answer them correctly or not. So therefore, if you if you take example of certain previous year question papers, once you read passages and try to attempt some questions based on that passages, that would strengthen your familiarity with the concepts that we discussed today. Also, this is for any section of CLAT UG examination, or for that matter, any other examination, that whenever you're doing such questions, please divide your time and be mindful of how many minutes you are taking in attempting those questions, or how many minutes you are devoting in reading the passages. Right? So we'll stop here. Thank you.